Good evening. This is Rahul Reddy. Because of some technical difficulties, we're starting late. Emily, we do bring in immigration updates every week from 5 to 6 p.m. Central Time. Emily, what do we have today to discuss?
Today we want to talk about H1B lottery filings. It's hard to believe it's only 2 weeks away from the window opening up for the electronic registration. We're still getting approvals from last year's lottery for petitions that were filed in June. So we'll talk about the dates for the lottery, what the process is, where you should be at in your process in order to ensure that it's a smooth one for you. We also want to update on the $100,000 filing fee that was implemented by the Trump administration through a presidential proclamation back in September. Who has to pay it? Who doesn't have to pay it? Who do we not know whether they have to pay it or not? How are they handling those national interest exemptions? And then we'll talk about AC 21 portability, the 485J form, submitting that after 180 days in the event of a job change. How safe is it to do that? Is it possible that that will negatively impact the I-485 and the green card application? Lastly, we're going to update you on H4 EADs and delays that we're seeing there, whether refiling is an option when the card has not been processed, what are the current automatic extension rules, and how is the latest change requiring biometrics for the photo impacting and delaying H4 EADs today.
I'd like to discuss about the H1B lottery. As you know, that the USCIS has announced the lottery will be starting from March 4th and will end on March 19th. That only gives us for 2 weeks window to file the H1B lottery. And as we know that lottery system is going to be based on the wage level. That means that if I'm getting wage level 4, then I will be having 4 chances in the lottery. If I get only wage level 1, then I will get only 1 chance for the wage level. And if by any chance 2 employer files, they will go with the least wage level person rather than going with the higher wage level person. Now, are you able to log in and we will be ready to file right now, as if it seems, or what are the steps people need to take care of to file the lottery system this year?
Yeah, the form itself won't open until noon Eastern time on March 4th. So we're not able to actually do any data entry at this point. Where you should be is your company, if they do not already have a MyUSCIS account that is an H1B registrant account, they can create that account now. They can also connect their account with the attorney account now if they're working with an attorney. Beyond that, there's nothing else that can be done with the MyUSCIS portal to prepare. That being said, you should be working with the company, working with the attorney to make sure that they have your passport and your education documents, to make sure that they know the details of your job offer, your salary, your job title, your job duties, and your work location, so that they can start deciding on which SOC code they're going to use, what is the work location, and therefore which prevailing wage level applies to the salary that's being offered, so that you'll have a sense of what are your chances going to be in the upcoming lottery.
Okay, so Emily, what about the people? What are the chances right now to have? Do you expect the same number of applicants filing like last year, or is it going to be like less? Because one, the $100,000 is applicable for the people who are filing the H1B, for the people who are outside the country, and also there have been a little bit layoffs compared to last year. Though, do you expect lower number of people filing the H1Bs this year?
I do think it's going to be lower. Definitely from a job market standpoint, we expect to see fewer people being registered. At the same time, we are talking to some companies and are aware of some companies that even though it's possible that the $100,000 fee might apply because the person is outside the US, the companies might still be willing to pay the $215 to go ahead and register them in the lottery, see if they get selected, and then they have until June 30th to decide whether to file or not. That gives them time to see what if the $100,000 fee gets blocked by a court. We do still have 2 ongoing court cases for that. And maybe if it is blocked, then they can proceed to file. If it is not blocked, maybe they won't file. that means we might have a likelihood of a second lottery, because if people are selected in the first round and then don't file to fill up the cap, we can see a second lottery happening this year.
Okay. Anything else, Emily, before we go to the next topic?
Yeah, and I also want to mention we received an update of what the new registration form is going to look like in the My USCIS portal. What new questions are they going to ask in order to verify how many chances you're going to get in the lottery? And it's a little bit surprising. Same as before, we just have to fill in the beneficiary name, their date of birth, their country of birth, country of citizenship, passport number, and then whether we're filing in the master's cap or the bachelor's cap. The new questions are, what is the wage level? And you just click a button for level 1, 2, 3, or 4. And then what is the area of intended employment? And for that, it's just a free form text box where you could fill in, we don't know what they want. Do they want the city and state? Do they want the county? Do they want the metropolitan statistical area? Do they want the address? They didn't say. And so I think that there's a likelihood that people will fill out anyway and they want to for that. But it's very surprising to me that they don't ask for the SOC code. They don't ask for the salary. They don't ask for the job title. And so they're just putting people kind of in the honor system where I'm going to say, yeah, I'm going to pick level 4. And if they get 4 chances in the lottery and they get selected, then it's going to be at the time of the H1B filing where they will look at, was that the correct wage level for this particular registration based on how you're filing your petition now. So I'm very surprised at that.
Emily, does the $100,000 fees applicable if I am in United States on F1 or H4 or L1 or L2 and want to convert into H1B in United States?
So if you're filing
In the new lottery.
Yeah, in the new lottery, if you're filing it as a change of status, the $100,000 fee does not apply.
What about all the people who are coming from outside the country? They are going to apply in the lottery. For them, the $100,000 is applicable, is that right?
Correct.
But at the time when we apply for the lottery, they don't have to pay the 100,000. It's only when we apply for the H1B they have to pay the $100,000 lottery. Okay.
Yep. So they have till June 30th to decide whether they're going to pay that or not.
And moving into the next topic for about the $100,000 fees, there are a lot of people that ask me question, Emily, that if is the $100,000 fees applicable? If I have an I-140 approval, I have used up 3 years of H1B. I have an I-140 approval. Now I'm in India right now. Is the $100,000 fee as applicable? The answer is simply yes. The $100,000 is applicable if you're outside the country. Simple. If you're outside the country, the company is filing a consular processing, it is applicable. Even though you are not going through the quota, even though you already have an I-140 approval, it is applicable. Only if you're within United States, any of those visa statuses, and you want to convert into H1B, the $100,000 fees is not applicable. Anything else?
All right. What about the 485J portability? We do a lot of consultations with people before they do a job change when their 485 has been pending for more than 180 days and they're concerned. Is USCIS going to agree that this job is a same or similar occupation to the one that they were originally sponsored for? Should they be worried about that? How much does USCIS really look into it?
We have not noticed many denials on the 485 applications when people have moved from company A to company B. Even if the job description is a little bit different, I mean, if they are working on Java, Java software, and then now they are working on SAP, we haven't seen any denial. Now, of course, if they moved out of the software profession, though, they definitely will be in trouble. But if they are within the same profession, we have never. There may be one exception that I may have seen out of the thousands and thousands of cases that I came across, but in general, I've not seen. If somebody loses the job, though, definitely if there is a gap between company A and company B, there is a risk that they may deny the 485 application. If the person has lost the job with the company that has filed the 485 application within 180 days, there is a chance that they may get the 485 denied when they move to a different company. Also, Emily, that is it required for the company B to file a 485J supplement when they move to different company? It's not absolutely needed for them to file a I-485J supplement, though. However, when there is an RFE on that particular topic, or if there is a 485 interview and you're no longer working for the company that filed for the 485 and I-140, though, you should carry the I-485J supplement with the current company that you're working. Otherwise, they will deny the 485 application. But in general, it's pretty safe to move out of the company and join a different company if it's after 180 days that the 485 has been filed.
Yeah, I think they're very broadly interpreting that same or similar occupation. I mean, AC21 has been around since the year 2000, 26 years going on. So even though we've only had the supplement J form since 2017, going on 9 years, AC21's been around for 26 years. I don't think I've ever seen a denial of a 485 due to AC21 issues. I don't even know if I've seen an RFE on it. So they definitely are, they definitely look at it, but they look at all the factors. They look at the job duties. They're not going to base it on the job title alone. They're not going to base it on the SOC code alone. They're not going to base it on a big reduction in salary or a change in work location. They just look at the job duties of the two jobs and say, is this a similar occupation?
H4 delays, what is the solution, Emily, right now? And we don't have the 540-day rule where we have told people, hey, you can cross a border if you have a valid I-94, and then probably based on your spouse's H1B approval, they will extend the H4. Now we don't have that option.
Mhm.
What options do they have, though, since the automatic extension is not there from October 30th of, if you file the EED extension after October 30th of 2025?
Yeah, number one, file early, file in premium processing with the H1B if you can. We are still seeing H1 and H4 oftentimes approved together in premium processing. Now we still have some new glitches to deal with the H4 EAD that's delaying it a little bit, which we'll talk about. Filing an amendment plus extension of the H1B to file that even earlier, and then adding in the H4 and H4 EAD can be useful as well if you're filing in premium processing. Beyond that, litigation really is all there is, because expedite requests are going nowhere. Seeking assistance from your congressman or senator is going nowhere. You know, they're claiming it's within normal processing time, so you just have to wait. But litigation is definitely something to consider once the EAD has been pending for about 3 months. We have started seeing this biometrics popping up again for EAD applications, specifically for H4 EADs. USCIS changed its policy in December and announced that they will no longer use the photos, the passport photos that you submit with your application. Now, instead, they're going to require you to go to the application support center to do your biometrics so they can take your picture to put it on your EAD card. So for applications that were filed in December and January, we've been seeing those biometrics notices issued. I think the most recent one we had, the application was filed in early January. The H1 and H4 were already approved in premium processing. And then mid-February, we received the RFE saying you're going to be sent for biometrics. And then you have to reply back to the RFE claim, showing that you've done the biometrics, but they're not sending the biometrics notice at the same time. So there's going to be a delay, number one, to get the RFE, number two, to get the biometrics notice, to reply back to the RFE, and then finally have the EAD issued. I don't know how long that delay is going to be, because we're just now starting to see the biometrics appointments.
Anything else, Emily, before we go to questions?
Nope.
Questions are coming up for those people whose visas have been prudentially revoked. Can they travel within United States, especially to Puerto Rico, Hawaii, or within the continental 50 states? We don't see any problem in them traveling within United States. So please make sure that you carry all the documents, that the case has been dismissed or the ongoing case, what it is. And I'm assuming that it's a very minor case. It's not a major case. If it is a major criminal act, definitely we want you to check with an immigration lawyer before you do any act. But in general, we have seen no problems when these people traveling within the United States.
Nirvana says for the I-485s filed in the last quarter, October through December of 2025, do you know how long it's been taking for approval? And is the gold card eating away visa numbers from the employment queue? I think that we are, let's see, it's February now, so we're not seeing approvals yet for cases filed in the fourth quarter of 2025. I think probably anywhere from 6 to 12 months is pretty standard for that process. As far as the gold card, we have no data on how many people have applied for it. I think the number is probably quite small. We have no idea how many people actually got approved for it and whether their priority date is current in the EB1 or EB2 NIW categories. So we have no idea how much of the cap that is using up at this point. We'll have to wait and see until maybe we get some updated statistics for the next quarter. The most recent data that came out was through October 2nd.
A question that is coming is how much quota we're expecting to spill over from family-based to the employment-based. We have presented this before. We estimated between 50 and we have estimated between 50 and 60,000 green cards may be spilled over to the employment-based. We could not predict with accuracy how the dates are going to move, but there will be a spill. We're expecting some spillover coming from the family-based to the employment-based because of 72 country span that we have right now.
Raza says, my EB3 485 interview is scheduled in the local field office even before the final action date is current. Does it mean all pre-processing is completed? In a perfect world, yes, but no guarantees. For USCIS is very inefficient these days. They've had a lot of senior people with institutional knowledge leave, especially at field offices. And so everything's very haphazard. So it doesn't really mean anything that you're being called for an interview. Is probably not a good thing that they're calling for you for an interview and they can't even approve your case. So what's the point of all of this? Why aren't we just waiting until the final action date is close to being current so that they could actually approve you shortly after the interview or right at the interview? But it does not necessarily mean they've completed everything already.
Second. Any chances for 100K fees get removed based on the litigation? There are, I would say that very less chances is my guess. Now, of course, some of the lawyers may disagree with me, but in general, we have seen that courts siding with the administration whenever they put any restriction for the people who are outside the country as compared to when they are inside the country.
Sutejin says, how is the B2 change of status? How RFE approval? Honestly, it's too early to tell, at least with the new flavor of RFEs. Now, up until December, I would say the few RFEs that we were getting, they had nothing to do with an H1B being filed. They were just your kind of standard B2 RFEs, prove to us that you have a residence abroad and that you have the financial ability to support yourself. Now, with these new RFEs that are mentioning the H1B, that are mentioning the matter of Healy and Goodchild case, that are mentioning that your intention now appears to be to stay indefinitely, and that's not in line with B2, and not mentioning the online guidance that says you can look for jobs during B2 time. We haven't had any results yet for cases that our firm has handled the RFE response yet. So it might be another month or two before we know what works and what doesn't work, unfortunately. I have seen 2 denials in the last week for people that have filed responses previously, not with our firm. So I don't know what those RFE responses looked like, but we have started seeing some denials.
Second.
Aga says, does having California unemployment-based medical insurance for emergency healthcare count as public charge for the 485 application based on the new rules. No, it does not. So when they're talking about public charge, they're talking about actual like welfare benefits, SNAP benefits. There's a specific list, TANF, I think is one of them. But if you are getting unemployment after a job loss, that's money that the company has already paid into the state. And then if you're paying for your health insurance through that, should not be considered a public charge at all.
Is expungement of dismissed case, is it a good idea? Does it make anything better or worse for the immigration standpoint? Expungement of any criminal record does not make any good, it's not a good idea for the immigration at all. It's definitely is a bad idea. But however, there are certain times because of other reasons other than
Maybe having technical issues here. Chaudhry says, is there any data or cases you guys have seen on increasing scrutiny of green card holders by CBP, even with all the valid documents and no prolonged absence? No, we're not seeing issues with green card holders being able to enter the country. No increased scrutiny there, as long as they're not staying outside the US for more than 6 months. They're not bringing any kind of thing into the US that they shouldn't be bringing. They're not visiting countries that the US is not friendly with politically. But your run of the mill green card holder, we're not seeing any kind of issues with travel right now.
Garu is asking the question whether expungement of a criminal record will have any positive implications on the immigration or negative implications. There are no positive implications on the immigration. There are only negative implications for the employment, for the immigration based immigration issues. But sometimes for you getting the employment, it may become beneficial if you expunge the record because they would not be able to look into the record though. If by any chance you're choosing that option of expungement, make sure you get all the documents. If you get any document certified, get 10 certified documents of each of those things. And the expungement record, you need to get the certified copy of those things because there are sometimes for employment purposes, it may be advantage, but for immigration purposes, it's not an advantage.
DKJ says, what would USCIS do if your employer boosted your wage for an entry-level job to wage level 4 to increase your chances? Would they say, no, you're level 1, even if your salary is level 4? No, they wouldn't do that, but I think they would be highly skeptical of, does the company actually have the ability to pay that salary and is it reasonable? And then really at the time of your extension, or if you file a transfer to another company, you can guarantee they're going to be vetting to make sure that you were actually paid that wage, that you have the pay statements, and they may even ask for bank statements to show that you actually received the money. So you don't want to do any kind of hanky-panky stuff there. Yes, that is possible. If a company really needs someone, that's what we're saying with H1Bs is these are highly skilled people, sometimes key people for the company. The company might be willing to pay a level 4 wage even if it's not a level 4 job, but they've got to back it up and actually follow through with it for the entire 3-year period. And then when you file your extension, if you're staying with the same company, I doubt it would be okay for them to drop it down at that point. So they're going to have to stick with it and actually follow through with it in order to make that work.
Nan is asking this question that if the birth certificate has been registered late, are you expecting any RFEs? And how to respond to that if there is an RFE? We are noticing some RFEs if the birth has been registered late. In this Nan case, the birth has been registered in 2022. But it's not a big deal. They will ask for supplemental documents. You can get 2 affidavit of births. You can get it from your parents and your cousins. You can get other documents supplementing it. For example, hospital records, school records, Aadhaar card, PAN card, ration card, election card, any government records that shows your date of birth. All those things, if you can provide it, though, we have never seen any denials on it. And you may not have all the things what I told, but you probably will have some documents, which I have listed it right now. But definitely, whenever there is an RFE from the RFE on the birth certificate, though, I always recommend that you consult an immigration lawyer who also has experience in India too.
Monica says, I'm on H1B, got laid off, and want to move to H4 without an EAD. Can I later convert to H1B if I get a job? How can I apply for that? And what is the effect of the $100,000 fee? So yeah, you can file a change of status from H1B to H4 on an I-539 application, and then you can later file a change of status back to H1B when you get the job offer. Since you won't have an EAD, you'll want to file that H1B in premium processing because you won't be able to start working until it's actually approved. It's up to you if you want to try to file that yourself. You can file it online, or you can work with an attorney for that, or your husband's company's attorney. And if you're in the US filing a change of status from H4 back to H1B, the $100,000 fee does not apply.
If somebody don't contact our office guys to see if we have any job, that's we don't provide employers. You have to find the jobs. But for the gentleman who's asking that for an F1 visa, I'm not getting an internship, I just want to give a tip to him that the internship on the OPT does not have to be paid. It can be unpaid also. So in the period of STEM extension, it has to be a paid, but in the period of in the period of the OPT, though, it can be unpaid internship that is allowed in the OPT period.
Jill says, if I'm outside the US and have a stamped H1B until September 2026, can my company file for an extension without the $100,000 fee? That is the question that we do not have an answer to yet. There are people that have filed those cases in December and in premium processing, and they have been put on hold without any explanation. But my guess is it's because USCIS doesn't know whether the $100,000 fee applies or not. And so they're trying to decide how they want to handle those. But so we don't have an answer yet.
Gentleman is asking question, can I file the EAD extension before 6 months? I have my H4 already extended. I would recommend, yes, you do file EAD extension before 6 months. I want you to do one other favor to me. File within the span of 180 days too. So let's say, for example, you have an EAD expiring in let's say January of 2027, and you have the H1B extended, H4 extended to 2029. What you can do is that file a EAD extension right now, which is more than 180 days, and somewhere in August of 2026, you file one more EAD extension. If the first one gets approved, the second one will get denied. If by any chance the first one gets denied, the second one will be approved. The reason we want you to file earlier is you know that there is a lot of delay in the EAD. So for that reason, you can. There's another gentleman who asked a question. The EAD is pending right now. Can I file H4 and EAD again when my spouse is filing the H1B extension? Answer is yes, you can and you should.
Ram says, my EB2 priority date is May 2015. My son is 16 years old. Is it possible to get the green card in the next 5 years? So we do have the current inventory of people who've already filed the 485 and are waiting for a green card to become available, or waiting for that to process. And this is for people who have a priority date before January 2015. There are 43,000 people in line in front of you, not counting January through May 2015. This is EB2 and EB3 India combined. USCIS last year approved about 7,000 EB2, EB3 India 485. So we have 43,000 applications and they're approving 7,000 a year. With that math, that would suggest closer to 6 years to get to January 2015. Then we've got to get from January to May. So it may not be good. Of course, we don't know what the spillover might be from this travel ban. We don't know how many of these people have two 485s pending, one in EB2, one in EB3. I think it's a relatively small number, but it's really hard to predict, but it doesn't look good based on the numbers that we see right now.
Harini is asking the question, my husband changed the job and did not file the I-485J supplement. Can I travel on advance parole? I don't see any problem whatsoever at all for you to travel in advance parole. And there's some rumors going on that the at the airport they are not allowing people who have an advance parole. That is a lie, guys. We have no problem. We have no reports that anybody is getting blocked for trying to travel on advance parole at this point of time.
Minkin says, will the H-1B extension trigger the $100,000 fee if the candidate is outside the USA? Yes, absolutely, unfortunately.
Okay. One second.
Vivek says, are you expecting this $100,000 fee to change in the near future with as the proclamation is until mid 2026? I believe the proclamation goes through September 30th, 2026, which is the end of the fiscal year. I'm expecting them to extend it. That's my guess. I think they're accomplishing somewhat what they want by getting people stuck outside the country with no way to come back. So yeah, I think that it's likely to continue unless the court blocks it, which doesn't look good at this point.
RC is asking the question, stuck in India because of the interview start, can I travel US on B1 visa and transfer to H1B? If your intention is to travel on, get a H1B once you come into United States, you cannot travel on B1 visa because that will be considered a violation of the terms of the B1 visa. Definitely and a lot of people ask me this question, hey, I'm not getting a slot for H1B, can I apply for the B1? We do not recommend that you apply for the B1 if your slot is not getting done for the H1B.
Palash says the H4 I-539 was applied in February 2025 and still no response in the Texas Service Center. That's pretty unusual. I don't see that many go that long. It's likely to be considered outside normal processing time now. So you should be able to at least put in a service request. Of course, those service requests are taking 30 to 60 days to get a response. And a lot of times the response is a non-response, but that is something that you can do to try to get it moving besides litigation.
Can I enter 15 days before the H1B stamp expiry date and then file for the extension? That's the word I think so. It says contention, so I'd say probably is an extension. I would definitely recommend that you contact an immigration lawyer. Why are you staying outside the country for such a long period of time? I definitely would recommend to fly as soon as possible if you have a job. My main question is that do you still have a job or the underlying H1B stamping? So if that's not there, you definitely should not come into the United States.
Venu says, my spouse's H1 change of status to H4 is pending. I'm planning to extend my H1, which is going to expire in August 2026. Can I apply for the extension? And how will this impact my spouse's H1 to H4 change of status? Yes, you can go ahead and file your extension. And I would recommend applying for an H4 extension along with it because your current pending H4 is going to be approved only till August 2026. And if it takes till August 2026 to get the approval, you might not have enough time to turn around and file her extension based on your extended H1B. So go ahead and file both H1 and H4 extensions.
A lot of people are having a lot of speculation why March visa has been delayed, visa bulletin. We don't know why it's been delayed, but we are not expecting any significant movements in the date, especially for the EB2 and EB3, if that's a doubt that you have. If there is any movement, though, the movement probably will show up in the October of 2020, October of 2026. That's when it will show up.
Ting says, if my 485 is approved before 180 days, do I still need to stay with the same job until 180 days have passed? And once I get my green card, how long do I need to stay at the same job? There's no requirement. Once you're a green card holder, you are basically a free agent. As Rahul always says, you can go be the CEO of Microsoft or you can go flip burgers at McDonald's. You are a green card holder. There's no requirement to stay with a company that sponsored you for any length of time.
Does the GCEAD renewal require fingerprinting? May not be, but sometimes they are requesting fingerprints. Right now, we have seen fingerprint requests for the H4s, we have fingerprint requests for the stem extensions and OPTs. We haven't seen any GCEAD fingerprint requirements at this point of time, but they may pop up. All these things they're doing only to delay the applications. Question.
Kath says, I'm on L1A with an approved I-140. I'm in my second year of the initial visa. My employer is persuading me to move to the H1B lottery if selected. My priority date's October 2025. Is it recommended to stay on L1A? Well, the risk of staying on L1A is what if you hit your 7-year limit and your priority date is still not current? So that is usually the reason why you would switch to an H1B, because the H1B allows you to extend beyond 6 years because you have an approved I-140, whereas an L1A does not. Now, can we guess whether your priority date will become current within the next 7 years of your L1A time? May not be accurate. So it might not be worth it to stay on L1A. I don't see any downside of moving to H1B. And if you do get on H1B, you've got more options in the event of a job loss. So it's actually better for you from the employee standpoint. Let's see. User DG says, is it possible if someone has Mexican permanent residence to get an H4 visa appointment in Mexico? Yeah, so the new rule about third country national processing is you need to apply in your home country, your country of citizenship, or your country of residence. So if you are a permanent resident in Mexico, you should be able to apply for the visa in Mexico.
Lot of predictions with regards to how many H1B lottery applications will be applied this time, though. Now, if we go back to the history from past 7 years, though, what we have seen last year, there were approximately 360,000 applications. And the previous year, the fiscal year of 2026, that means the application of lottery in March of 2025, they were 360,000. And before year, that is fiscal year of 2025, is 480,000. And the previous year, fiscal year 2024, that is 2023 March, there were 780,000 applications. Now, of course, at that point of time, the way the lottery system was conducted is quite different. It was some of the companies filed multiple applications that was completely discouraged. So coming to right now, do we have an idea how many of those applications filed last year, that is out of 360,000 applications, how many of them were inside the United States? How many of them are outside the United States? Really, we don't have an accurate picture, but based on my estimation, though, in the fiscal year of 2026, approximately 30 to 40% of the people were in United States. So the approximately 101,000 to 135,000 applications were in United States. And approximately around 60 to 70% of them were outside the United States. That between 200,000 and 235,000 people were outside the United States. Now, here is what I am thinking, though. There may be some people who may apply right now for the lottery system who are outside the country, hoping that hoping somehow the 100,000 will be exempted from them. But if the $100,000 fees is not exempt, because there are a lot of people who applied for exemption, the USCIS has not granted any exemption. Nobody has granted any exemption at this point of time. If there is no exemption, though, I am expecting, Emily, this is my guess. Please, don't blame me for this, guys. I'm expecting about between 90,000 to 120,000 applicants, including the bachelor's and master's quota right now. If the $100,000 is effect, because we are not expecting more than 500 applications applying through $100,000 fees. And there is a lot of changes that have been done recently within the United States, a lot of enforcement, a lot of big companies are not filing the H1Bs. So between 90 and 120,000 is my estimate. Now, please Don't blame me on this one, guys. Don't quote me on this one. I have not been accurate on it, but this is my estimate at this point of time. What about you, Emily?
I'm gonna go closer to 150 to 200,000. I think there's a lot of people that are in the US that are eligible, people that have been on F1 and have not gotten it in the last 3 years. Then we've got people that haven't gotten it in the 2 years, and people that just graduated, people who are on H4, people who are on L2, people who are on L1 that need to convert to H1B, people are on TN. There are so many people that have better options sometimes, or there are reasons to switch to H1B from inside the US that I think those still use up the numbers. So that's my guess, but yeah, we're always wrong, so it means nothing.
Can I get the house rental income? I'm an H1B. This question is coming from Mega Tansdeep. Absolutely, you can. No problem with it. Will not cause any problem. You will have to pay taxes on it. That's all it is. Absolutely no problem with it.
Niku says, is there any current issue of delays with L1 stamping like H1B stamping in India currently? No, my clients have not had any issues with getting L1 or L2 visa appointments in India. Seems to be mainly H1 and H4 that are problematic because they expanded the social media vetting to those categories. We are definitely seeing more scrutiny of L1 applications, as particularly if they are under the blanket L approval. But beyond that, the visa appointments are readily available.
Sandeep is asking, do you expect a lottery in the H1B this year? I do. I do expect a lottery this year. For those people who don't know what a non-lottery means, they have to go back a lot of years. Somewhere in 2008 to 2010 is where we did not had a lottery, though. For a couple of years, we did not have a lottery at that period of time. So if there are not enough number of applicants received, that means that not 65,000 applicants received, not 20,000 for master's applicant received, then they will grant the H1Bs for everybody, and they will extend the time. So because they have given only until March 19th, they will extend the time, and sometimes it may be extended to 6 months to 10 months now. Although my guess and Emily guess is that this year for the fiscal year 2027, starting in March 4th to March 19th, we're expecting the lottery to be filled out.
Gayatri says, can I apply for my H4 EAD before 180 days if my H4 is valid for longer? Yeah, I've not had an issue with USCIS when you file the 765 a little bit early because of processing times. Definitely we're doing it in prior years when EAD processing was taking a year. We were filing way early and never had an issue with that.
Asrita Hashu from Facebook has this question. I am filing request from ombudsman, from the senators. My EAD is expiring in February 21. I would recommend you should try to go to the court litigation. Now, when you go to court litigation, don't expect you will get a result within 30 days. But yeah, most probably the best option would be court litigation. Yeah, you can try all other efforts, but the chance of success there is about 2 to 3%. Everybody is trying, and they don't take senators and congressmen that seriously when you try to expedite through them.
Sunil says, my wife's H1B, an old one, was picked in the lottery in 2014 and expired in 2017. She never worked on H1B. Can we use that H1B to be cap exempt now? I am going to assume that that 2014 H1B approval was approved for consular processing, not a change of status with an I-94. And when an H1B in the lottery is approved for consular processing, you're not actually counted in the cap. You only are considered to be counted in the cap when you actually get that visa stamp in your passport or when you enter the US in H1B status, which means that she cannot transfer that to another employer and be cap exempt now.
People are asking how much it costs for a court litigation for getting the EAD approval. It's definitely not considered to be expedited process because they are supposed to approve the EADs within 3 months. And if they don't, you can go to the court to get it. Normally, the price range is between $5,000 to about $8,000 is the range that I can tell at this point of time. But if you need more details, you can consult with Stephen Brown in our office. He's the court litigation partner in our office. He takes care of all those stuff.
Harini says, my husband changed his job and has not yet filed the supplement J. Can I travel with my approved advance parole? No issues with that at all. There's no requirement for him to file the supplement J in order for you to travel.
My 485 has been approved. They're telling me to return the AOS EADs and advance parole. Is it required to return? Just mail them out. What are we going to do with that EAD? It's an address that since they're requesting it, give it a mail. They sometimes feel that it may go in the wrong hands and people may use the EADs. And believe me, there are a lot of people who use the other people's EADs to work and green cards to work. So they're a bit more concerned about it. Just mail them out. How difficult is it for you to mail them out? I recommend just to mail them out.
Anjan says, can I have H4 EAD and H1B at the same time? Well, you can't be in two statuses at the same time, but you could technically have two approvals at the same time and choose which one you want to be on. And you could potentially switch from one to another through what we call the margarita switch by taking a trip to Mexico, using automatic visa revalidation, having a margarita there, and coming back with whichever approval notice you want to be your new status. So if you're on H1B and decide, you know what, I want to switch to H4 and use my old EAD that's not expired, you can potentially go to Mexico, show your H4 approval notice with that I-94 that's not expired, come back in on H4. Now that EAD is valid and you can work using your EAD. If you want to switch back to H1B, do the exact same thing if you have the valid I-94 on both of them.
Um, G. Chowdhury has this question though. Have you seen a lot more scrutiny for the people who are green card holders who have extended absence, prolonged absence out of the United States? Yes. We definitely recommend that if you're outside the country for more than 180 days on a single stretch, you're planning to come back, please contact an immigration lawyer before you come back into United States. Don't just come in. If there are any criminal records, though, you must have already checked with an immigration lawyer before you travel outside the country. Now, I'm not speaking about speeding tickets that does not involve any DUI. They are fine. But if there is any speeding tickets with DUI or any other criminal records, other than just a small, simple speeding ticket, you should consult an immigration lawyer before you travel outside the country. Also, I got a question with regards to the CBP, date correction in the CBP on the I-94. Please do not contact the CBP directly by yourself. I would strongly recommend that you contact an immigration lawyer. One other thing is that everybody, please check your I-94 online. We see that error so many times. When, let's say, for example, you have a passport stamping until 2028. Now you're entering into United States and you have a H1B approval until 2028. You enter into United States. Don't just sit down. Go online to CBP website and check it whether they have given an I-94 until 2028. If by any chance they did not give you until your passport until your H1B expires, you can contact an immigration lawyer. They can fix it so easily. Do not contact the CBP directly without speaking with an immigration lawyer. There are so many people who don't check their I-94. Now, when that I-94 expires, that means your valid status expires. And if your status expires, that's a problem. Now, once you come in, though, let's say, for example, your H1B was expiring in 2026, January, and you entered in 2024, but in 2025, you filed an extension and you got the extension approved. It won't reflect online. It won't reflect online. That's, you don't have to worry. But if you entered into United States, your visa stamping, your H1B is expiring 2028, please check if it's expired in 2025 or 2026. You need to contact an immigration lawyer immediately.
Vineet says, if the H1B is getting expired in October, can I file the extension now instead of waiting until April? Yes, but it needs to be filed as an amendment plus an extension, requesting a start date of now or within 6 months from now. So your end date is going to be cut short a little bit, but yes, that can be done.
Memudri asked this question. My friend who's an H1B lost the job. What do you suggest to do a F1, or do you suggest to apply for the jobs? Definitely, he should apply for the job. If he can get a job within 60 days, he should go for the H1B job. Now, here is one thing though. Is it a real job? If it's not a real job, don't involve in them. It is crime to collaborate with a company to file a H1B when there is no job. And specifically, we're speaking about the internal projects that does not exist, or they are fake internal projects. And if you're paying money for the H1B, that is considered to be fraud. If you're paying money for the company to run you the payroll, that is fraud. You should not do that. Now, I'm not telling consulting companies bad things. If they found a job, let's say, for example, there's a Coca-Cola company, ABC Consulting Company has a job for you to do in Coca-Cola company, and that is completely allowed. Doing a H1B definitely is a better option than moving on to F1 or B2. Now, previously, we may have recommended for you for B2, but I think so, Emily and I am a little bit changing our opinion right now. We're telling probably F1 may be a better option than that of B2, because we're notice some firebacks from USCIS on approving the B2s at this point of time. So probably F1 may be a better option though. So you may want to consult an immigration lawyer to evaluate, is F1 better or is it B2 better? But one thing is that if you have a job offer with some company, genuine job offer, is H1 better or F1 better? H1 is better. Now, is H4 better than F1 or B2? Definitely, if you have an H4 option, H4 is much better than B2 or F1.
King PVB says, is there any lawsuit against USCIS for canceling the 540-day automatic extension for EADs? No lawsuit has been filed yet. There is at least one in the works looking for plaintiffs. The part of the issue is that a lot of people had the 5-year EADs, and so it's not yet time to renew. So it's hard for us to find plaintiffs that have already been harmed by not having the automatic extension because people haven't needed to renew yet. But I think that will likely be coming in the coming months.
And this question is coming from Vinay Babu. He's a Bablu. He's asking this question. Can we travel to the third country for visa stamping? Third country for visa stamping? Absolutely not. This is our recommendation at this point of time, guys. If you have a visa appointment, cancel it, don't travel it. If you already have a visa stamping, let's say until 2027, you want to have a plan to travel, don't travel, stay in the country. Don't travel outside the country at this point of time. And if you're traveling, we strongly recommend to contact an immigration lawyer. Now, if you contact me that I want to travel and then you pay me the consultation fees, this is what I will do. I will take your consultation fees and tell the same thing, don't travel, in a very nice way. Nothing changes, guys. I won't change. I won't tell differently here and tell you differently there. Just because you pay me the money, I won't tell you differently. I will just take your money and tell you very, very sweetly, the very sweet way not to travel. That's all. Your money will just tell the same thing in sweet. So it's not worth, guys.
Peter says, if there are 50,000 spillover from family-based to employment-based, how many might be issued to EB2, EB3 India? So if we have 50,000, they're still split up between EB1, EB2, EB3 based on the same percentage. So 28% of that can go to EB2, 28% of that can go to EB3. So that's 14,000 extra to EB2, 14,000 extra to EB3. The majority, if not all of those, will go to India, possibly somewhat China, because assuming they're not used by rest of world. So if it brings rest of world current, any leftover can then go to India or China. But if rest of world needs those, then the number will be less. And we don't know how many people rest of world are already pending. Well, I guess do we know that? We might have that data. I might have to look up a little bit.
But overall, when I look into the visa bulletin, though, the rest of the world final action date for the EB2 is backlogged until April 2024, which, I mean, seems to be irrelevant because labor certification is taking a long time. There are some exceptions for national interest waiver. So I would say that a good majority of the EB, a good majority of these 50,000 extra could go to Indians, is my guess at this point of time. A majority of them. Will 50,000 go? Maybe not. Will 30,000 go to Indians? Probably yes. Probably 50 to 60% of them could go to Indians, is the estimate at this point of time.
Yeah.
You disagree, Emily? Are you good?
No, I agree. Yeah.
Anything else, Emily?
Well, I guess we are out of time. I know we started a little late, so we stayed a little extra this time. Thanks everyone for joining us. We'll be back again next week at Tuesday, 5 o'clock Central Time. Thanks for joining.
I'm sorry for the technical troubles, but for those people, if anybody wants to contact me, Emily, or any of our colleagues, the link is provided there. And we do have a daily conference call where you can participate in it. And it's always good for every month, just once come there and listen to other people, though. Here, we don't have an interactive session. We just answer it. There it will have an interactive session. The link is provided there for you to join the half an hour Zoom call that you can every single day that we have been conducting from 2014, the 2012 onwards, so approximately 14 years. Previously, it was a conference call. And of course, when the Zoom came in, we moved into Zoom. Thank you for tuning in.